Hello, and welcome to Hunt and Hunt's litigation team as it talks you through the various stages and the various options faced when you're involved in commercial litigation, which is a pretty scary process, I think. But we've got really friendly lawyers here to help you through it. But while I say friendly, they're also fierce. That's just the way they've got to be. Catherine Ballantyne's the head of the litigation practice here at Hunt and Hunt in Melbourne. And Catherine, we're going to have a bit of a chat through the benefits of mediation and negotiation, or probably negotiation then mediation, versus litigation. So quickly, negotiation, mediation, what's good about those?
Well, the good thing about a negotiation or a mediation is that you're in control of the process. So the outcome has to be agreed. So the outcome, you have certainty because you know what the outcome is when you agree with the other side. And it's also you can do some creative things that are not available within the court processes.
Is that one of the ones where if everybody's unhappy, it's probably the best outcome?
Yes, they do say if everyone walks away unhappy but okay, then the mediator, especially in a mediation or a negotiation, they've done their job and it's and that's
Yeah, and the big benefit there is it controls the costs for the client, doesn't it? More so than litigation.
well, if you can do it up front, the costs are significantly less and it's also quicker and time is always money. The longer a court case goes on, and they can be a year or even more before you actually get to trial. Whereas a negotiation or mediation, you can get to an outcome much quicker, much more cost effective, and people generally before the litigation starts and before they've spent significant sums on legal fees are going to be more likely to put that money into a settlement. Whereas once they've spent a lot of money on legal fees, sometimes there's a tipping point and it becomes more cost effective in their mind to roll the dice and go to court.
Mm. And it is a roll of the dice, though, isn't it? I mean, anything's possible when it's completely outside of your control.
Well, that's exactly right. I mean, a court case is being determined by someone who doesn't know either of the parties. So I
Or
don't know
cares about
if
them?
the person's a good person or a bad person. I've had people who say, oh, that person's a terrible person. I say, well, the judge doesn't know this. The judge only knows the evidence that we present. And they're only looking at this one specific instance. They're not looking at the person's life history and they don't care about the person's life history. So they're looking at this one instance and whether the evidence fits in with the person who's brought the case's claim. So it really comes down to evidence. I often say to people, the courts aim for fairness, but it's not always fair because it has to come down to evidence and what can be proved. And that can be a really difficult concept.
But the biggest difference I imagine between the first two, the mediation and the negotiation versus litigation, is that litigation you're going to have to do an awful lot of work, going through an awful lot of documents and paperwork and interviews with people, preparation, expert witnesses, all of these things. You don't necessarily need that with the negotiation process, do you?
No, or mediation. So, it's always good if you're prepared and you can put your best foot forward and show the other side why they're at risk if the case ends up in litigation. But you don't have to go through all of that process. So it's much more cost effective. And it really is both parties, if you can settle early, even before litigation, both parties are usually far better off. I mean, nobody takes into account not only the financial aspects of litigation, but the stress. It's incredibly stressful. And also if you're a business owner, it takes a lot of time away from your business where your eye should be on the ball, on your business, growing your business. Being in litigation really takes away from that too. And that's the non-financial side of things that often people forget about.
Mm. And if we talk about practical solutions, which is what we talk about at Hunt and Hunt, I mean, it's much easier to control that, isn't it, when in the first two phases, the negotiation, the mediation. I mean, you're thinking about the commercial aspects of it. What am I happy to live with here? Not what am I right or wrong, but what am I happy to live with as an outcome?
That's absolutely right. And a good commercial outcome can be negotiated. And if it can be negotiated, that's going to be far better than putting it in the hands of the courts out of your control. You're much better off keeping control and trying to negotiate a commercial outcome. And as I said, sometimes it can be quite creative, the results that you can get, so that there is a good outcome for your client.
Mm. So if we put them into little brackets here, and again, correct me if I'm wrong, but I've got mediation and negotiation are just scary, and then I've got litigation, which is very scary.
You're probably correct. I would say that's probably correct. And look, you know, that's why we're here, to make it less scary and help you through the process. But it is always, always better if you can settle before you end up in litigation. If sometimes it's not possible, sometimes you have someone completely unreasonable, sorry, on the other side, and you have no choice but to go through litigation. And that's what we're here for, to help with the strategy. Things, once you're in litigation, you can settle at any time during the litigation. There will usually be a court ordered mediation as well, because the courts are trying to get people to settle, because they understand too it is usually a much, much better outcome for people if they settle before they go to trial, which more often than not is all or nothing. It
Mm.
really is a roll of the dice.
Yeah, and we often hear of settlements being made during the court case.
Yes, and in fact, more and more the courts actually on day one or day two of the court case are sending people off for another mediation, even if they've had one. If the courts feel, they hear the opening submissions from the barristers and they think this is a case that really should settle, they'll often send them off for a mediation again. And many times they actually do settle. And if they don't settle, then they go back and hear the rest of the trial. But it's actually a very common scenario now, much more than it was, say, 15 or 20 years ago. The courts are really seeing the benefit of mediation and alternative dispute resolution.
Cool. Well, there you go. That's a bit of a walkthrough on the differences between them and the practical part of it. So, what does it actually mean when you don't get your negotiation or your mediation? You got to walk off to the courts. And so, thanks for your time, Catherine. And we'll come back with another thing to talk about in a few minutes.
Thank you.